Physician Pre-Sentence Report Service, and today I'm going to go through what's been in the news that we've all been watching, and that is Samuel Bankman-Fried, and the feds followed him all the way down to the Bahamas for a massive fraud dealing with crypto. And he has a problem. By the time the feds get involved with you, they already have a case built. And so with that case, he really only has a couple options. So I'm going to share my screen. And here we go. So here he is, a gentleman, young guy in his 30s. And right now, I did some quick calculations. He has 8 counts against him. Counts 1, 2, 3, and 4 are 20 years each. Counts 5 and 6, I really wasn't able to see the year component. Count number 5 is Title 7 Federal Regulations, Section 180.1. Title 7 U.S. Code, Section 9.1 and 13A5. Both of them through Title 18, Section 371. And then count number 6, and then there's count number 7, and lastly, count number 8. So he's got a lot in front of him. And as he gets extradited back here to the United States, he has a lot to think about, but really only 2 things, because the Department of Justice has all through the news, which all of us have been reading, is that they have told us he's built a house of cards on a foundation of deception while telling investors that it was one of the safest buildings in crypto. So it's not really good, doesn't look good for him. And he's brought along with him people in politics, people in Hollywood from all parts of the globe. And so there's many, many years he's facing in prison. And I'm not an attorney. And I have to say that when the feds came to my front door and then came to my medical practice, I was totally unprepared. But I'm very much prepared today. I mean, I've had my medical license restored in full. That won't help him. But I sure, from what I've learned, I hope he has the ability to rule out the voices that are going to enable him and allow him to sit back and take ownership of what he's being charged with, because that is the only way he's going to be able to get through this. And he has 2 paths. First path is trial. 98% of those who are even indicted on the federal side get convicted and end up guilty. If he goes to trial, the prosecutors are going to love it. They're going to want to go to trial. They're going to want all the free publicity. If he pleads, either way, he'll be guilty. He's going to need to go through the pre-sentence interview, where he's going to gather all of his biographical background information, character reference letters. I hope he's going to need letters of character, and not just saying he's a nice guy. He's going to have to find people that are willing to say they've known him when he's done good deeds, he's done charity, he's done community service. Maybe he'll be able to do some community service if he's allowed out on bond. I don't know that he'll be allowed to do that. But his only option is going to be able to take the amount of months he has before he goes before a sentencing judge to think hard and begin to work on a personal narrative, which is going to be his story in a letter form that's going to have to be written and rewritten by people that he maybe does not know, but he trusts, to be able to get him to create a heartfelt narrative that he believes that's the truth and from the heart, and that he can then go through in first person with the probation officer. Because the probation officer is going to be the first person that's going to talk to him. And this is during the interview. And then that person is going to go ahead and do the investigation. And there's not going to be a lot of people out here that are going to speak kindly. And hopefully that the narrative is going to be heartfelt enough to make it into the pre-sentence report so that the judge can review it. And then he's got to be prepared during the court hearing or during the sentencing hearing to be able to have an allocution dialogue with the judge. And judges, we share the screen. They're facing here, how would you like to be United States of America versus Samuel Bankman-Fried? It's all through the news. None of it's any good. But judges, and I'll go through it here, closer, come up a little bit. There are a lot of judges, and they all say the same thing in different ways, that the allocution or the conversation they're having is important. Judge Cobb from Nebraska, they're interested in a defendant who has the capability of introspection and comes to grip with the impact of his offense on others. They particularly value a defendant who understands the harm he's done to others. It's important. Judge Ralph Erickson for the U.S. Court for the 8th Circuit in North Dakota, and he recalls that he had a defendant who the victim died of overdose of drugs that the defendant had given, and the defendant told him that no punishment would be enough. If he could go back, he would change everything. Allocution matters. Judge Levy from Maine, Portland, Maine said, it's important. He can be persuaded if the defendant is sincere rather. Judge Marc Bennett from Iowa, Sioux City, allocution's critical. He's a noted authority on the subject. He's published articles on allocution, surveying other judges, gauging their views on the importance of allocution in their court. And he likes to have a conversation with the defendant. He said that's very important. Judge Cynthia Bashad of the Southern District of California also, they want to know, they want the defendant to apologize to the victim and their family, especially if they're in the courtroom. They want to know, like the child, that he has done wrong. They're looking for insight from the defendant. This Samuel, he has a lot to be able to, he has a large hill to climb to convince himself and the court that he has realized what he has done. Judge Marcia Krieger of District of Colorado City, she has seen allocution where the defendant has shown sincere and thoughtful about what he has seen, of what he has done. They've shown remorse. They need this judge in District of New Jersey. The defendant needs to step up and take responsibility for his crime rather than leaning on circumstances. They need to really take this to heart, says another judge of England from California. If you're going to take responsibility, then take responsibility. This is, it's a very big deal. A lot of this is very important to these judges. Judge Rice, it's reasonable, according to Rice, a reasonable amount of effort to pay restitution. What they want is they want the client. If Judge Rice said that it's important, if the sincerity is important in restitution, and they want to ask the defendant if he's harmed, what they're going to do about it. If they want to know that if they want the defendant to make a reasonable effort to pay restitution. And if they can't pay, they don't want to see the defendant driving up to court in a $900 a month vehicle while they're on bond, while they're paying no restitution. This allocution during court is a very big deal. And so, as I try and get back to the interesting. Okay, so I'm trying to get back to the therefore, he's going to have a number of months where he's going to have to sit and think, because he may have time between when he's extradited back to the US because he's still in the Bahamas and when he officially appears and then has to go for the pre-sentence interview. And in that period of time, he can't have his enablers around. He has to, from the heart, take ownership for the damage he's done to victims and accepted responsibility for it and try to come to grips with what sort of plan he can put together for himself as to what he can do for restitution or going forward. In other words, what is his plan that he thinks he can do in reality, understanding that he's going to go to prison, but taking responsibility for the crime. Obviously he doesn't have the money to pay back for everything that everyone's lost, but he has to be able to accept that responsibility. If he's going to go to trial, it's a lose-lose for him. If he's able to put this in writing, and it's going to take many rewrites of this personal narrative until he's able to actually believe it and it's from the heart. Next, he has to be able to have the probation officer believe it. And next, he's got to be able to have a conversation with the judge in a courtroom full of people who probably won't believe him. But he has all this time to think about it. And hopefully he takes this time to heart, because this is his only period of time before the judge passes sentencing. And once that happens, then, all he has left is, the attorney to speak in his behalf, and attorneys are paid to speak in his behalf. For sure, before the pre-sentence interview, if there's a psychiatric issue, there'll be psychologists and psychiatrists involved. The first step back, for sure, he can take the programming. That's not going to put a dent in the number of years he could be facing. And so his only way through this is to accept responsibility for the victims that he's harmed and be able to explain this in a personal narrative, and then be able to have a conversation with integrity and honesty in public to the judge, to the court. I hope you found this helpful, and hope everyone has a good night and a good week, good holiday, and a safe one.